Welcome to EUPrivacyForAll Session47 on GDPR, Powers of the Supervisory Authority, Article 53. In the frame of negotiations regarding Article 53, European Parliament stressed that supervisory authority could certify controllers and processors and put in place effective mechanisms to encourage confidential reporting of breaches. Among others, EU councils suggested that investigations in the form of data protection audits would be added, review on certifications, the capacity to notify controller or processor of an alleged infringement, or to obtain access to all personal data and to all information necessary to the performance of its tasks, and to obtain access to any premises. In the frame of corrective powers, additional prerogatives were added to supervisory authorities, such as issuing warnings, ordering to comply, imposing a temporary or definitive limitation on processing, and regarding authorization and advisory powers, a long list that was kept almost all in the final draft was once again provided by EU Council. Article 53 on the powers of the supervisory authority stresses three kinds of powers. First, the investigative powers, to order the controller or the processor to provide any information required, to carry out data protection audits, to carry out a review on certifications, to notify any alleged infringement, to obtain access to all personal data and information necessary for the performance of the supervisory authority tasks, to obtain access to any premises. In the frame of corrective powers, it would be the possibility to issue warnings, to issue reprimands, to order to comply with data subjects' requests, to bring processing operations into compliance, to communicate a personal data breach to the data subject, impose a temporary or definitive limitation, including a ban on the processing, to order rectification, restriction, or erasure of data, to withdraw a certification, impose an administrative fine, or order the suspension of data flows. Regarding the third bucket of authorization and advisory powers, the DPA will be able to advise the controller, issue opinions to the national parliament or government or any other institutions, to authorize processing, to issue opinion and approve draft codes of conduct, to accredit certification bodies regarding certification mechanism, to issue certifications, adopt standard data protection clauses, authorize contractual clauses, authorize administrative agreements, and approve binding corporate rules, BCRs. In the end of this long list of powers conferred to the DPA, it is stressed in paragraph 2 that the exercise of the powers conferred to the DPA pursuant to this article shall be subject to appropriate safeguards, that is to say, effective judicial remedy and due process, in compliance with the Charter of Fundamental Rights of the European Union. Additionally, each member state shall provide by law that its supervisory authority shall have the power to bring infringements to the attention of the judicial authorities, and it may provide by law that its supervisory authority shall have additional powers. A key recital in GDPR is also recital 100, as with regard with the tasks of the supervisory authority. Effective powers of investigation, corrective powers, sanctions, authorization, and advisory powers are once again put forward. It is also made clear that the right of every person to be heard before any individual measure which would affect him or her, and the obligation to avoid superfluous costs and excessive inconveniences for the persons concerned, is at the center of the powers given to DPAs. Therefore, transparency is required on their side too. Each legally binding measure should be provided in writing, be clear and unambiguous. It may give rise to judicial review. It is also referred to in Article 56.3 the fact that a supervisory authority may confer powers, including investigative ones, on a seconding supervisory authorities or staff involved in joint operations. Article 79.3b also reminds us that without prejudice to the corrective powers of one supervisory authority, each member state may lay down the rules on whether and to what extent administrative fines may be imposed on public authorities. Currently, Article 28 of the directive already identifies those three buckets of powers, that is to say, investigative one, access and collection of all information necessary, intervention ones, that is to say, delivering opinions regarding operations, ordering the blocking, erasure or destruction of data, imposing a temporary or definitive ban on processing, warning, admonishing and referring the matter to national parliaments. And finally, the power to engage in legal proceedings or to bring violations to the attention of the judicial authorities. As much as in GDPR, the decisions of the supervisory authority which give rise to complaints may be appealed against through the courts. What should accountable data controllers and processors get prepared for? First, being aware of their obligation, anticipating the powers of national supervisory authority regarding the information to be provided, data protection audits, review on certifications, the obligation to notify any alleged infringement, to obtain access to personal data or access to premises, to issue warnings or reprimands, to comply with data subjects' requests on supervisory authorities' request, to bring some processing into compliance, to communicate a personal data breach to the data subject, to impose a temporary or definitive limitation, including a ban on processing, rectification, restriction, erasure of data, but also the fact that a DPA could withdraw certification, impose administrative fines, and have a whole set of advisory powers. Controllers and processors should also bear in mind that supervisory authority powers are subject to appropriate safeguards, that is to say, effective judicial remedy, but also, on the contrary, that they have the power to bring infringements to the attention of the judicial authorities. Each member state may provide additionally into the law that the supervisory authority shall have additional powers. Today, the consistent implementation with regard to investigation and certification may trigger some questions. It will be clarified by EDPB and upcoming practices by national supervisory authorities.